A judge just blocked Loudoun County Public Schools from punishing a boy who asked, "Why is there a girl in my locker room?" Now, Emily, you wrote about this story. What's going on here?
Yeah, so this is Loudoun County Public Schools in Virginia. And in May, a female student was using the boys' locker room under the district's policy 80/40, which allows kids to use bathrooms and locker rooms based on their subjective gender identity instead of their biological sex. So there's a female student in the boys' locker room, and she is secretly filming them saying things that you would say if there was a member of the opposite sex in your locker room. So they said, "There's a girl," and "I'm uncomfortable," and "That's a female, bro, get out of here." And because LCPS equates gender identity with sex, they actually found the boys guilty of discriminating against and harassing the female student instead of the student that was videoing them. We know for sure that she wasn't investigated, and as far as we know, we don't believe she was even punished for filming, which is actually against the school's policy. In September, the boys sued LCPS through Founding Freedoms Law Center and America First Legal. So on October 10th, Judge Leonie Brinkema granted the boys a preliminary injunction, which means that LCPS can't punish them or label them sexual harassers until the case makes its way through court.
Now, on what planet, because this seems all upside down and right is wrong and wrong is right, on what planet is saying "I'm uncomfortable in the bathroom" somehow harassment?
Yeah, it is upside down, and that's essentially the boys' argument, is that it's upside down, that they have a right to privacy and that they should be allowed to object if a policy breaks that right. The problem is the school's interpretation of Title IX, which is the federal statute that prohibits sex discrimination in federally funded schools. Usually, Title IX applies just to biological sex, but because LCPS extended the definition of sex to include a person's feeling of being male or female, the school is arguing that the boys actually violated Title IX by harassing the girl and not agreeing that she's a boy. LCPS also puts forward a lot of disputed facts. So they say that the boys never went to a teacher to disclose that they were feeling uncomfortable, but the boys say they actually did it on at least 2 occasions. And their version of events is backed up by the Virginia Attorney General, who reported the school to the Department of Education in June. And then in September, the Department of Education agreed. They found that LCPS had violated Title IX because Title IX is supposed to make sure that bathrooms and locker rooms are separated by sex.
Wow. And now these boys ended up raising a lot of money for their case, right?
Yeah, so the judge required the families to post a $125,000 bond before the case could go to discovery, which is pretty unusual. The money is to recoup the school district's losses in the event that the boys lose in pretrial discovery. But the school district also has federal insurance to recoup them of losses anyway. So it's unclear why the judge even made that requirement, but luckily they didn't have any problem meeting it. They were able to fundraise more than $130,000 and post the bond.
That's great news, Emily. Thank you for following this case. The next step in this case comes discovery in whether Loudoun County Public Schools can actually prove harassment. To read Emily's article and any updates that we'll be publishing in the future, you can go to thedailycitizen.org.